What is going on, IP family? I am your host, Dave. We are back with another live. You guys will actually be seeing this on June 8th, 2025, but I'm recording this June 7th, the day before. I have some graduations to go to, a high school graduation, not a graduation, an open house to go to high school as well as college in my hometown of Muskegon, niece and nephew. So shout out to them for graduating, and it's going to be tough to make it back across the states, 3-hour drive. So I figured I'll do this pre-recorded, put it out tomorrow, or put it out today rather, Sunday, June 8th. And I may be in a chat. So as I'm kind of driving back, I may be in a chat, going back and forth with you guys. And we have a lot to get off into today. Before we get off into it, please hit that like button for the YouTube algorithm, as well as hit that subscribe button to be a part of the IP community. Some of the things that we are going to talk about here today, a woman actually in Illinois has just got a patent on easy access pants for the disabled community. So we'll talk about that. We'll talk about Cenant. He filed for trademark protection on his name, Cenant. We'll talk about the pros and the cons of that and whether or not that is legal. Mark Zuckerberg and the Eminem's producer, they are kind of going back and forth on a copyright infringement lawsuit. Hey, Buc-ees at it again, man. Buc-ees is at it again, suing another company. This time, I think this lawsuit for trademark infringement is justified. We'll talk about that. And then last but not least, we will talk about the lawsuit of the week. We'll go through it. And this one is going to be a pretty good one. This is coming from Stingers. The golf tee company are suing LIV Golf for a trademark infringement. So we got a lot to get off into. Like I said, please hit that like button for the YouTube algorithm, as well as hit that subscribe button. And again, Shark Tank, unfortunately, has gone away. Season 16 ended a couple weeks ago. So that's going to be around August 16th, or back in August or September of this year. So we don't have any of those highlights to show, so to speak, but we still do have a interview of the week. And this company is actually a Shark Tank company, Frame Your Feline. I got a chance to talk to Brian and Christina a while back. I think they're out of California. They have this cat picture frame, and it's a pretty cool, nifty invention. And I just do want to play a snippet from that particular interview. So let me kind of pull that up here and kind of cue up everything. And then I'll come back after we play the snippet, and I'll give you guys my thoughts on this one. So let's go.
Wait, you could sit back and have an idea, which I think a lot of people do, but they don't take action on it. And who cares? You could go down.
You see the cat in the picture frame.
It's you miss 100% of the shots you don't take, right? Wayne Gretzky. So you have to put yourself out there. You've got to put your product, your imagination into motion in order to create and then have it come out. If it fails spectacularly, okay. If it does fantastic, great, right? But if you remain frozen, you're going to get nowhere quick, and you're going to have a life of regret. and it's better to try than not to try.
So shout out to Brian and Christian. Definitely go check out that full interview on the page. And again, just following up on what Brian is saying, and I 100% agree with them. The whole part, or a big part of this channel, is to bring on people who essentially started from the bottom, and they're giving you their story. And hopefully you as the audience, it gives you motivation to say, okay, I'm going to get started today. We all have ideas. We all have kind of businesses that we want to start, whether it's a product or a service. And I always have mad respect for the people who actually do something. So again, you can say what you want to say about Brian and Christina in terms of their product, their picture frame. And I don't think they did get a deal on Shark Tank, but again, they did something about it. They put forth motion and came out with a product and went through that whole process, and to the point where they're actually selling a product. And I think that means more than anything, because, hey, man, we're all going to die someday. When we get on that deathbed, we would much rather, or I would imagine that you're going to much rather say, I'm glad I did it, regardless of whether or not it's successful or not, as opposed to having this thought process of, man, I wish I would have started that business, or I wish I would have kind of did this or did that. So shout out to Brian and Christina for actually coming out with the product Frame Your Feline. And again, it seems like it's getting some traction. Like I said, they were on Shark Tank this past season. They did not get a deal. However, I can assure you that that does not stop it at all. They're kind of full sales ahead, full, throttle forward, and they're going to have success. So shouts out to them, man. It's cool for me to kind of do all these different interviews because, hey, some of these interviews are some of these companies are going to blow up, and it's going to be cool for me to kind of look back 5-10 years from now and say, hey, I interviewed that company that sold for $50 million, $100 million, or hopefully that sold for $1 billion, and being able to catch them on the way up. I actually interviewed Protein Pints, Paul Reese, I forget the other co-founder's name, but I interviewed them like a year and a half ago, and again, they were just bubbling, and now, man, you're talking about they're blowing up. They are blowing up. They're in Kroger's. They in Myers, which is a grocery retail store in Michigan. I think they're in H-E-B or Heb down in Texas, another retail grocery chain. They're in Target. So they have their Protein Pints is the product, the name of their product. Essentially ice cream with, it's packed in protein. They are in a ton of stores. That really just happened over the last couple of years, and being able to kind of have that interview from a year and a half ago, almost 2 years ago. Man, it's cool. So again, inevitably, some of these companies are going to do good or going to blow up. All these companies are going to do good, but some of these companies are going to blow up when you're talking about tens of millions of dollars, hundreds of millions of dollar companies. And it's good to be able to have that interview as they were on a rise. So shouts out to Brian and Kelly again for Frame Your Feline. Let's move on to the next part of the show. It's not going to be a long show, man. I actually have a UFC fight to get to. So I'm going to make this short and sweet. But this next portion of the show, Jennifer. So Jennifer Kraft, shout out to Jennifer. I'm not going to read this article because I already kind of did a fuller video on this. But, man, part of my ebook, and I do want to kind of plug the ebook here because in the ebook, Got IP, that link is going to be in the description. That's kind of really talking about how you get an ideal and then how you monetize the product, and it's kind of describing each step in that process. In this ebook, I talk about we all want to have an ideal, and the two easiest ways to get an ideal is, number one, and we all kind of working these jobs for 10, 20, 30 years. You gain some skills as well as the gaps in the process, what's not working well, why it's not working well. So in a great way, hopefully when you stop working at that job and say you want to come up with a product or a service, to be able to fill that gap, that's a good way to come up with an ideal to start a business on. The second way is problems that you encounter on a day-to-day basis. What are you doing that you hate to do or that is always painful? I got a couple of them that I'm in the process of coming out with, patents as well as some software, whatever the case may be. But in Jennifer's case, she's former athlete, former collegiate athlete, and I think she's currently a science teacher. Shout out to Jennifer. She's out in Chicago. I was just in Chicago yesterday, which is crazy. But you could tell she's in a wheelchair now. And I would imagine that being in a wheelchair obviously limits you, but one of those limitations is being able to go to the bathroom. You need help, whether it's kind of unbuttoning your pants, whatever the case may be, because, again, you don't have motion or mobility in your lower limbs. However, Jennifer has came out with a product. Let me see here if I can show it. Okay, I'll bring this back up. Easy to open, where you can see in the seam here in your more or less crotch area, it's a zipper that allows the person in a wheelchair, the disabled person, to unzip, take care of their business, that being use the bathroom, zip it back up and go about your business. So shouts out to Jennifer for coming up with that. And she actually, I'm not sure if so she actually, hence the title of the article, she secures a patent, U.S. patent for her easy access pens. I actually love the name too, easy access pen. So shouts out to her for not only coming up with an idea, but also getting a patent on this one. And another thing I will say about this is it's a design patent. So for those of you who don't know, it's really three types of patents. You have the plant patent, which we're not going to talk about because I've never dealt with that, but that is a third type of a plant patent. But the two most common types of patent are design patents as well as utility patents. Utility is overwhelmingly the more common patent. That's functionality of something. If you're trying to protect the functionality of something, the structure, whatever the case may be, you will get a utility patent. However, if you're trying to protect the ornamental or the look of something, you'll get a design patent. Now, in her case, in Jennifer's case, she actually got a design patent on her easy access pens. And that just kind of underscores the importance of the different types of patents, but also the design patents, which are, hey man, I was watching Shark Tank. It was a butt window. It was like some underwear, really for like kind of gay men, if you're out on the beach, whatever the case may be. And it's essentially was a window in the back, kind of showing you a crack. Again, it was a crazy pitch. And Mr. Wonderful, he offered the owners, they had a design patent on it. He offered the owners of the company $100,000 just for the design patent. He didn't want to take over their business. He didn't want to invest in their business. He just offered them $100,000 just for the design patent. So this shows you, just because you don't have a utility patent or just because you have a design patent, this stuff is still valuable. In Jennifer's case, she was able to get a design patent on this easy access pants. And again, it probably would have been difficult for her to get a patent on a utility patent on a pants with a zipper, just because we've seen pants with a zipper. That's not necessarily anything new. However, pants with a zipper in that crotch area, that's something new. And that's something that you can protect, not maybe by a utility patent. However, you can get protection on that by way of a design patent. So shout out to Jennifer on that. I actually reached out to her just before coming onto this stream here. And I'm going to try to get her on the actual podcast. So hopefully I can succeed in doing that. Yeah, she's out of Chicago, Illinois, as you see here in the right-hand corner, Chicago, Illinois. And yeah, man, shouts out to Jennifer for not only having an idea, but coming up with a product as well as protecting that product. We all know how important that stuff is. So with that being said, shout out to Jennifer as we move to the next part of the show with your boy, Cenant. Let me see if I can pull up this. This is important for a number of reasons. Let me see if I can kind of trademark search. There we go. There we go. Now, again, I did a video on this as well, so go check out that. But your boy Cenant, he actually filed for trademark protection on his name, as you see here to the right of the screen. And he actually, I think, did that maybe earlier, I think August of 2024, April of 2024, so a couple months ago. And a lot of people don't know, but you can get protection on your name. I'm actually in the process of filing a trademark application for a client on her name. Now, that may be a little bit more difficult to get through, just because to protect your name, number one, your name has to become synonymous with the business. So in Cenant's case, or say Joe Rogan, probably not Joe Rogan, say Ralph Lauren. We know that Ralph Lauren probably is his name, but we all know Ralph Lauren for the polo shirts. Think another example, Tom Ford. Tom Ford, we know him for, again, I think the gentleman's name is actually Tom Ford, credit to suits, but we know Tom Ford for the actual suit. I'll probably say to a lesser extent Joe Rogan, where you say Joe Rogan, we think of podcasting, even though Joe Rogan is the name of the host of the podcast. When you think of Joe Rogan, you think of podcast. So Tom Ford, Joe Rogan, Ralph Lauren, all those are names of an individual. But when you think of them, you think of the product or the service that they are providing as much or maybe more so than the actual name of the individual. And that's kind of really what it takes to get your name trademarked. Again, I think Donald Trump, that's probably another one. I'm not sure if he has his full name trademarked. I know he has Trump trademarked, but that's another person. When you think of Donald Trump, you think of maybe the buildings and the business and being the president of the United States, which is, again, a service. So that may be something that Donald Trump can get a trademark on, is his name. Because, again, when you think of trademarking somebody's name, you have to be able to provide that, okay, hey, this person, this name is synonymous with more so a product or a service and not of a person. And to the extent it is a person, you better show a ton of, some type of ton of data or evidence as to why a lot of people know this person's name and what they know that person's name for. So in Cenant's case, again, for those of you who don't know, he's a world famous streamer. So you think of Cenant, much like Joe Rogan, again, he has it in, class 41, which if I kind of pull up here, he's protecting this trademark and providing online videos featuring streaming, music, shows, video games, prank stunts that's not downloadable. So when you think of Cenant, yeah, it's a person. However, you think of him as streaming, which is the service that he's providing. And that's kind of what you really need to be able to protect your name as a person. Now, to the extent that it's not your name and it's somebody else's name, then it's going to be tough because you have to get permission from that person's name. But to the extent that you're trying to protect your name, then your name better be synonymous with a product or a service to be able to try to get a trademark on, and it has to be distinctive. So shouts out to Cenant, man. He's doing big things, and I'm glad that he's protecting his trademark because this stuff is valuable. It's considered an asset. You can get loans off of it. Heck, you can sell your trademark, your IP to get money off of it. So there's a lot of ways to monetize off the intellectual property. And a lot of times, man, when you have these younger guys, I think Cenant is maybe in his early to mid 20s, you don't think of them kind of being hit from a business standpoint, protecting the intellectual property particularly. However, Cenant got the right team around him to say, hey, man, let's go ahead and kind of file this trademark application to protect your name. So shouts out to Cenant for that. And yeah, let's move on to the next one. Eminem. Actually, Eminem's publisher has sued. And I'm not going to go through the article because I actually just kind of put out that article earlier today. But Eminem's publisher has sued Meta, formerly known as Facebook, for copyright infringement. So for those of you who don't know, and actually did not know this, from 1995 to 2005, obviously all the hits that your boy Eminem wrote, he doesn't control. I'm not sure if he owns it, but he doesn't control how those songs are being his publishing company, I think it's 8 Mile Style. Shout out to 8 Mile. But 8 Mile Style, which is the production company of Eminem, from 1995 to 2005, they control all the music that he made. And I actually kind of told this story where maybe back in 2010 when I was at Michigan State University, I was working like security at a summer fair in the Lansing area. And Eminem was performing. No, Eminem was not performing. However, 8 Mile Styles, which is a company, the owner of that company was in attendance for the different acts that was performing that night. And somebody was like, hey, man, that's 8 Mile's producer or whatever the case may be. And his wife, I'll never forget this, his wife had a fat rock on her hand in terms of a wedding ring. And again, shouts out to 8 Mile Style. Shouts out for them to protecting the trademark. Again, man, regardless of who's trying to infringe your marks, you got to be able to infringe your IP. You got to be willing to protect your intellectual property, or else what's the use of having an intellectual property? In this case, it seems like Meta was using a ton of 243 songs of Eminem on his various platforms, Instagram, WhatsApp, Facebook, allowing users such as you and I to kind of be able to pull the songs and use them for their videos. And again, it seems like Eminem producer 8 Mile Style, they initially sent the cease and desist letter to Meta, and it seemed like it was some negotiations, but I'm not sure if things broke down or whatever the case may be. But 8 Mile Styles, they actually sued Meta for copyright infringement, and that's where we here are. So I mean, I'm gonna keep a lookout on this one. I actually should have probably did this in one of the lawsuit breaks down, but hey, nonetheless, I am going to keep an eye out on this one and see how this thing goes. What a lot of these lawsuits, man, unfortunately, they end in settlements. And unfortunately, the terms of those settlements are confidential and therefore not publicly accessible. But I am going to kind of keep my eye out on this and see how this thing goes. Again, they're suing a Meta for $109 million. So this is not a $5-10 million. This is not no small stuff. You're in the big leagues when you sue somebody for $109 million. I think 243 songs, and I think each song they want like $150,000. So they're trying to get paid. We'll see what happens with it. I'll keep you guys keep you guys updated on the latest and greatest of that. With that being said, Buc-ees. Let's pull up Buc-ees, man. Hey, at this point, I'm not sure why anybody is messing with Buc-ees. Buc-ees that had one company. They was like a gas station or a convenience store. Buc-ees made this company change their business altogether to like a lemonade stand. Another company they sued and they actually settled out with. I'm not sure the details of that settlement. Like I said, typically those are confidential. However, Buc-ees is suing somebody else. This time in, what did they say? North Charleston, which I'm assuming that's South Carolina. Is that Charleston, South Carolina? Let's take a look at the news anchor and see what they're saying about Buc-ees. I think Buc-ees may be some of those ones. I thought Buc-ees were stretching, but I think, and you'll see here why I say that in a second, I think Buc-ees was in the right on this one. Let's go. Hold on, I guess I didn't pull it up here. Let's go.
Of the iconic beaver logo that's grown to be a fan favorite. Our Caroline Spikes tells us new details.
When you go online to Born United's website, you'll see all of the involved products have since then been taken down. But when I went to their North Charleston location today, it was a different story. Here you can see one of the products.
So you have to listen to what they're saying. So I'm assuming Buc-ees sent this store, which apparently is a pretty popular store in the Charleston area. They sent them a cease and desist letter. And I'm assuming that they saw that they were selling these Buc-ees shirts on a website. So the store actually pulled the shirts from the website. However, they did not pull them from the actual physical stores. They pulled them online, but they did not pull the shirts from the actual physical stores. I'm telling you, man, business is a dirty game. So I just wanted to kind of let you guys know what's going on. Buc-ees sued someone or North Charleston-based clothing store for trademark infringement based on copying their famous Buc-ee, their beaver logo. And when Buc-ee sent them a cease and desist letter, the store pulled the shirts from their website. However, they kept selling the shirts in the store, and that's why Buc-ee slapped them with a lawsuit. I'm not sure why anybody's playing with Buc-ees at this point. We all know Buc-ees is trigger happy when it comes to filing lawsuits on people. So again, to the extent that you are willing to take that chance and spend money and time and resources dealing with it, I don't know. I don't think it's money well spent, but you guys have to let me know in the comments. Let's go.
Mentioned in the lawsuit with a cartoon beaver.
And again, this is what they're selling. Now, you see the beaver on the left-hand side of my screen above Buc-ees. And I have to say that I think Buc-ees has something with this one. I think this Buc-ees that they're selling is like a army logo. Army has an army hat on and maybe an army shirt on. However, I do think that Buc-ees has a great chance at winning this lawsuit to the extent that it goes all the way. It seems like they were already taking stuff down. So obviously I would imagine that this clothing store is going to continue to take this shirt down. But I think Buc-ees was in the right with filing this lawsuit. Let's go.
In the store's window. The lawsuit says Buc-ees did send.
So you see Born United, man, just kind of going back a little bit. Look at this.
The lawsuit says Buc-ees did send a cease and desist letter, but Born United continued to sell the product.
I mean, this is a nice size store, and I think they said they had like 7 to 8 stores, a physical store. So this is a decent sized company.
It says the logo was used on shirts, shorts, and patches, infringing on the Buc-ees trademark. The famous gas station said in the suit this irreparably damaged their brand, not giving permission of any kind to use their, quote, Buc-ee marks. The suit says Buc-ees was first founded in 1982 with a handful of valid trademark registrations since 2007. Born United is a locally owned, veteran-operated store selling a variety of goods with a variety of designs. There are 8 locations, some here in the Palmetto State, with others in Virginia, Indiana, Florida, and Tennessee. I spoke with the owner today. In a statement, he said, quote, "We love and respect Buc-ees, and we are happy to discuss any concerns that they might have. Born United stands for God, freedom, and country. We are strong supports of our veteran, military, and first responder community," end quote. For more on this, you can head over to this web story on live5news.com. Reporting in Charleston, I'm Caroline Spikes, Live 5 News.
Bryson will.
So shout out to the company here, man. And this, like I said, I think this is a great learning lesson. Number one, again, man, shout out to the veterans. We love the veterans. I was just at the game today, the Detroit Tigers. They actually lost to the Chicago White Sox, and they were big ups to the veterans. However, you guys have to be careful because a lot of times when you're selling shirts, when you're selling apparel, especially, the cool thing is to kind of use something else that people know of and maybe kind of twist it up a little bit and sell it and think that you're not going to get slapped on your wrist. That's essentially what they did. We all know the Buc-ees beaver typically has that with that red hat on that you see on the screen, and they took the red hat off of them, put an army hat on them, and threw like some army clothes on them, and and people may like it and people may buy it. However, that's a trademark logo that you're using, and hey man, you are going to get hit with the trademark lawsuit for using that logo. So again, man, you can do this at your own risk, but I definitely will not recommend doing this for people who want to kind of follow suit at that. In terms of, like I said, using a trademark logo and then maybe trying to add some additional stuff to it and sell it and think, okay, we're just kind of essentially trying to piggyback off their notoriety and kind of get these shirts sold. Again, man, shouts out to the veteran. I understand what you guys are trying to do, but I thought that was that was not going to work 9 times out of 10. And again, shouts out for Buc-ee for keeping his hand on the trigger finger. And man, let's go to the last one of the day. Stingers, which apparently is a LIV Golf team. Let me try to pull up the website. Pull up the lawsuit here. Here we go. Again, please hit that like button for the algorithm as well as hit that subscribe button. And here we go. So Stinger Tees, doing business at Stinger Golf, is suing LIV Golf for trademark infringement. Let's go through the complaint here really quickly. It's not that long of a complaint, so we'll go through it and then we'll go from there. So Stinger, you guys see it? Yep. Has been a Norfolk, so it's an Ohio company. I didn't realize that Stinger Golf was in Ohio, a Midwest company for over 25 years. Stinger Golf launched its popular tee in 1998, and today it manufactures approximately 20 million golf tees per year. Man, is that many people playing golf? As detailed below, nationwide sporting goods stores, well-known golf clubs, and online retailers sell Stinger's golf products. Many golf tour professionals use Stinger Golf products. Excuse me. And this is actually going to be a pretty good one, and I'm going to show you why this lawsuit is actually a pretty interesting and a good learning lesson from a trademark infringement standpoint. Despite the prominence of its inherently distinctive and famous Stinger marks in the golf industry and its prior trademark registration for the Stinger marks, LIV willfully and brazenly, brazenly adopted and is using the same Stinger trademark, both as a team name and as a brand to sell competing golf merchandise. So it seems like LIV Golf has named one of their golf club Stingers, as well as they're selling shirts with Stingers on it. A representative sample of a side-by-side of a legitimate Stinger Golf product and defendant Stinger products are shown below. So it seems like Stinger Golf is selling shirts as well. So this is Stinger's Golf, the plaintiff, the T company to the left. Then you have to the right LIV Golf Stingers brand that's selling shirts. The logos are different, but the name is the same. To be clear, Stinger Golf has not and does not approve of or authorize LIV's use of the Stinger's marks. Moreover, LIV and its unauthorized goods and services are likely to cause consumer confusion and create an erroneous association between Stinger Golf and LIV. Stinger Golf brings this lawsuit to maintain control of its brand and reputation, to protect the significant investment of its time, money, and energy. We're going to skip the jurisdiction and venue, and we're going to talk to the parties. But as we do that, I do want to say one thing. If it's anybody that you want to sue, it's probably going to be LIV Golf, because they got that oil money, and we all know that oil money runs deep. So I would imagine that as we're going to finish off this lawsuit, but I would imagine that LIV Golf is going to settle, and I would imagine that they're going to pay that money as part of the settlement. They're paying these guys $100 million, $200 million contracts just to switch over from the PGA to LIV Golf. And I would imagine, like I said, if it's anybody that you want to sue from a infringement standpoint, LIV Golf is probably a good one, because they're probably just going to pay to play. Hey man, we're just going to essentially give you some money and let this go away. So I do want to bring that up, because we all know that LIV Golf has deep pockets. Let's go to the factual background. Plaintiff in the Stinger's mark. Since at least as early as 1999, the Stinger trademark by itself and in connection with other words and designs has been used on and in connection with various golf goods and services, including tees, hats, visors, club covers, ball marks, and other accessories. Stinger's Golf is particularly well known for its tees, which have become a staple in the community. Stinger Golf is a U.S. company that operates its own finishing and distribution facility in Ohio, where it puts out over 20 million golf tees each year. This in-house finishing operation allows Stinger Golf to maintain rigorous quality control standards and reinforces its reputation as a brand. Throughout its history, Stinger Golf has offered its goods and services to more than 1,000 green grass facilities, meaning those facilities incorporating public and private golf courses, driving ranges, and related offerings. Its customers list includes some of the most celebrated and distinguished golf clubs in the world. So it seems like, hey, everybody know about Stinger Golf according to this lawsuit. Stinger Golf specialty performance tees have been sold online and direct to consumers for more than 20 years. During this time period, Stinger's golf products have also been sold at several major off-court retail chains in the U.S. Okay, they're selling at Dick's Sporting Goods, Golf Galaxy. I never heard of Edwin Watts Golf Shops and Golfsmith. I've never heard of these last two. I've heard of Dick's Sporting Goods and Golf Galaxy. Stinger Golf also sells its products through a number of large online retailers. Let's see here. It's products carried by many golf industries. So let's see. Stinger Golf has a history of a loyal patronage by golf tour professionals, including players on LIV Tour. Stinger Golf has cultivated substantial goodwill in its mark through the consistent delivery of products manufactured under exacting quality standards. These standards govern every aspect of production, from raw material selection to final inspection, and reflect a relentless commitment to excellence. Stinger Golf products are not only distinguished by their performance and durability, but also by their premium finishes and consistent quality. You guys have to let me know, and I'm pretty sure we have some golfers watch this. Have you used Stinger's golf tees? And to the extent that you've used them, how do you like them? I'd like to know that in the comment section. Stinger Golf has also invested considerable resources, including but not limited to time and money, in the advertisement, promotion, and marketing of plenty of goods and services under the Stinger's marks. So it seems like, as we have here, they have 3 trademarks. They have a trademark on a word, Stinger, in class 28 for golf tees. They have a trademark on, looks to be a combination of a word and a logo for golf tees. And then they have, again, another combination, trademark on a combination of seems like a hornet in a word, Stinger, for golf tees, for retail and wholesale store services, and for custom manufacturing services. So for manufacturing the tees, for selling the tees, as well as for the actual tees. Okay. Let's go to what the defendants have done. More than 25 years after the first product sold under the Stinger's marks entered the U.S. commerce, and long after the USPTO issued the Stinger registration, LIV Golf began using the nearly identical infringing marks in the U.S. and in connection with the team name and various golf merchandise. The infringing marks identify one of 13 teams that participate in LIV Golf regular tournaments. So it seems like these are the Stinger marks. And apparently this GC that you see at the end of it stands for Golf Club, I think. So Stinger Golf Club. What do you guys think? Trademark infringement or not? Trademark infringement or not? Hey, it seems like they have a YouTube or IG page, 40,000 followers. Stinger's GC. Like you got the kid doing this thing here. You see the shirts there with the Stinger mark on it. Let's get back to it. The U.S. Patent and Trademark Office has already refused. Look, let me tell you this before we finish this. And again, obviously, I'm not saying this is a blanket case, but if you file for a trademark and the examiner at the United States Patent and Trademark Office refuses your registration because there's a likelihood of confusion with another registration, just kind of be on the lookout that to the extent that you continue to use that mark, you're probably going to get sued by the company that the USPTO refused your registration of. So in this case, the USPTO said, hey, we're going to deny you the ability to register this mark as a trademark because you have the Stinger's golf tees, or the Stinger's company that sell golf tees and have shirts and things like that. And to the extent that you're continuing to use the mark, again, as a person, as an attorney telling you this, you probably should be on the lookout that that company, in this case, Stinger's, is probably going to sue you for trademark infringement. The USPTO already said there's a likelihood of confusion. So you know that if you're going to use the marks, then the company is probably going to sue you. I'm not saying that that's going to be used in court, that it was, what's the name? But you can see that Stinger's, the company, they put they put that in their lawsuit that, hey, the USPTO already denied registration of the mark from LIV Golf Club for Stinger's because of our marks. So like I said, that just doesn't bode well for you. And I just want to let you guys be known of that. Also, another thing, kind of going back up here a little bit, if I was Stinger's, I probably would have filed for a trademark protection in class 25 for clothing, because it seems like, again, according to here, they're selling a hat, a golf hat. So in addition to golf tees, protecting it in golf tees and retail and wholesale store services, as well as custom manufacturing, I probably would have got it for class 25, which is clothing and apparel. So just kind of letting you know how I would have done things. Let's get back to it. So it says, look, the USPTO has already refused to register two of the defendants' applications to register Stingers as a trademark due to its confusingly similarity with the Stingers marks. That's not a good thing. Okay, so 3 years ago on April 6th, defendant LIV Golf applied to register the mark Stinger GC for essentially class 25, clothing, t-shirts, shirts, tank tops, jackets, so forth and so on. Later on that year, the USPTO issued a non-final office action refusing the defendants LIV Golf Stingers application for clothing under Section 2D of the Lanham Act. Specifically, the USPTO noted that LIV Golf and Stingers marks convey a highly similar commercial impression, especially when viewed in the context of golf-related clothing. I can see that. Additionally, USPTO noted that mere two letters adding at the end GC did not mitigate the likelihood of confusion, nor did the fact that one of the Stinger marks incorporated design remain the dominant element. So pretty much what they're saying is, look, Stingers. Let me get back to it. It's hard to see there. They're pretty much saying, look, just because you have this GC at the end, that's not going to take it out of likelihood of confusion territory. And just because you have this S as well, that's not going to take it off likelihood of confusion territory. I think if they were just using the S, they would have been good with that. But again, I guess apparently Stinger, according to the USPTO, the word Stinger still is the dominant form. Okay, let's go here. The USPTO did not find, okay, what they're saying, we already said that. Letter GC. In spite of this, the USPTO refused to register the infringing mark in LIV Golf, resulting knowledge from at least this point forward that the infringing mark is confusingly similar. LIV Golf has used the infringing marks to advertise. So they pretty much like, look, we know that the USPTO is telling us that this is a likelihood of confusion. We're gonna use these marks anyway, which is a big no-no. Further, undeterred by the prior refusals, on June 16th, so the following year, the LIV Golf reapplied to register two stylized versions of the infringing marks with the USPTO, again covering apparel and golf tournament-related services. They definitely wanted to use these marks. So I would imagine that second application in 2023 probably was, again, a combination of the word, the logo, and that probably didn't work either. So currently, the infringing marks appear prominently on the infringing domains as well as defendants' account pages. We just saw that. They got them on IG, Facebook, and TikTok. Plaintiff notified defendant that their use of mark was an act of trademark infringement. So essentially, they sent them a cease and desist. And what did they say? And it seems like LIV Golf blew off the cease and desist letter and continued to use the marks. From April 4th to the 6th of this year, so a couple days after my birthday, LIV Golf hosted the LIV Golf Miami tournament at the Trump National Doral in Doral, Florida. This high-profile event featured extensive use of the Stingers name and branding, prominently displayed on team uniforms, merchandise, signage, as well as digital platforms associated with the tournament. The tournament was broadcast nationally and internationally, drawing significant media attention and public viewership. The pervasive use of the infringing marks in connection with this event, particularly in context of golf-related goods and services, has exacerbated consumer confusion. Okay. And I want to see if they had some actual people that said they were confused. LIV Golf unauthorized use of the Stinger marks had led to actual. Okay, so they do have some actual confusion. Look, I just scanned these lawsuits, so it seems like they do have some actual confusion. Let me just tell you guys this: the best evidence you are going to have as far as trademark confusion is people actually saying that they were confused. It's no better evidence to people looking at the mark and saying, calling the Stinger Golf Tee Company up and saying, "Hey, I thought y'all was associated with LIV Golf based on the Stingers marks." That's the best form of evidence when trying to sue somebody for trademark infringement. Because again, trademark infringement is the likelihood of confusion. The two marks are similar such that you and I, as the average Joe, will look at the marks and get confused. And when you got people actually getting confused, hey, there's nothing else to talk about. So let's kind of get back to it and see what this actual confusion was. Let's see. On at least two occasions, individuals familiar with Stingers Golf Tees brand independently inquired whether Stingers was affiliated with the professional LIV Golf team prominently using Stingers' name, reflecting genuine uncertainty regarding the source of sponsorship of the goods and services bearing the mark. Such confusion underscores the immediate and ongoing threat to the distinctiveness of the plaintiff trademark and public association of it with plaintiff's longstanding commitment to quality and reliability. For the foregoing reasons, defendants' goods and services provided under the infringement mark are directed towards the same class of consumers. Thus, plaintiffs and defendants are competitors with respect to each other's goods and services. LIV Golf's use of almost identical infringement marks will likely to cause confusion, mistake, deception as to the source of the origin of LIV Golf's goods and services due to the defendant's use of the infringement mark in connection with the goods and services. Consumers will likely believe that LIV Golf goods and services are provided by essentially the plaintiff, Stingers. Let's see here. Do I want to read this? Okay, it's not that long. We'll read the count one here, and then we'll get you guys up out of here. As his first ground of relief, plaintiff alleges federal trademark infringement. We already read this stuff. Stingers has invested substantial time, effort, and financial resources promoting the Stingers marks in connection with the marketing and sale of its goods and services in interstate commerce. As a result, the Stingers marks, through widespread and favorable acceptance and recognition, have become an asset, substantial value as a symbol. Okay. Upon information and belief, LIV Golf is the owner and operator of and principally responsible for the content of the infringing marks. I would agree with that. Upon information and belief, LIV Golf advertises and offers services for sale using the infringing mark with the specific intention of misleading. Okay, man. So that's pretty much it, man. It seems like that's pretty much it. I would love to know what you guys think on this one. Like I said before, if you want to sue anybody, you probably want to sue LIV Golf because they don't want no smoke and they're likely going to pay their way out of it. I would imagine that they settle, or what they can do is get a license agreement from, again, and this is the importance of this trademark or intellectual property for that matter. You can probably get a license to use the Stingers name from the golf tee company and just get that money, pay that money, get a license, and then you'll be able to use it. Now, whether or not the golf tee company Stingers is going to allow that remains to be seen, but that's one of the things that I can see potentially happening just because I think LIV Golf will pay an exorbitant amount of money to be able to use the mark as opposed to not using the mark. Heck, they already got a team name, Stingers, so to be able to have to rebrand a team name, they probably don't want to do that. So as opposed to just changing the team name altogether, I can see them trying to pay a crazy licensing deal in millions of dollars a year just to use that team name. I can see that happening. And again, that's the importance of intellectual property. But I don't know. Stingers may say, man, just stop using our name and force them to rebrand. And that's well within the golf tee company's right. Like I said, some takeaways from this one. Number one, if you file for a trademark application and the trademark, the examiner at the USPT, the trademark office denies your mark by saying it's a likelihood of confusion with another company that already exists, just know if you continue to use that mark, that company is probably going to sue you at some point, or at least send you a cease and desist letter, because they're going to go through the application file and say, okay, hold on, he already knew that the mark was likely to confusion based on the examiner saying that, and we're going to see them a cease and desist letter, and to the extent that they don't stop, we're going to file a lawsuit. That's essentially what happened in this one. So just kind of be aware of your mark being denied a trademark as a result of a likelihood of confusion mark, because that can definitely be problematic for you going forward. And again, man, to the extent that you want to file for a trademark on something or come up with a team name, man, it'd be good just to make sure that you're not walking into a lawsuit, because this lawsuit stuff can be time consuming, it can be expensive, and just kind of not a good use of anybody's time. So those are just kind of a couple takeaways that I have. Let me know what you guys think in the comment section. Like I said, as we kind of close up here, some housekeeping items. Please go check out the ebook, Got IP. It's in the description section. Please hit that like button for the YouTube algorithm. And last but not least, hit that subscribe button to be a part of the IP community. Hopefully you guys enjoyed this one. I am going to try to be in a chat with you guys tomorrow as I'm kind of coming back from the open house. And hopefully you guys enjoyed this.